Hello, everyone. Welcome to the US PTO Hour about PTAB statistics. I'm Janet Gongola, and I will be your moderator today. I'm the Acting Chief Communications Officer at the US Patent and Trademark Office. Thank you all very much for attending this webinar. We're going to have a really interesting US PTO Hour session today. Next slide, please. First, we're going to talk about a new study involving high-volume filers and domestic university-related patentees who are involved in district court litigation and AIA trial proceedings. Second, we are going to unveil our new appeals dashboard. Third, we will share a variety of updates on information that we have previously released, but very recently added to. Those updates are for the multiple petitions study, the Orange Book and biologic patent study, and our AIA trial statistics. Lastly, and most importantly, we will take your questions. Next slide, please. To that end, if you have a question for our presenters, please email them to the address shown on this slide, USPTOhour, all one word, at uspto.gov. Please do not use the chat box or the Q&A feature in this webinar to submit any questions. Also, please send your question as soon as you possibly can. I'll be gathering those questions, organizing them, and then we'll relay them to our presenters at the conclusion of the webinar. Finally, the slides that we are showing in today's episode will be available very soon on the USPTO Hour webpage. A recording of this episode also will be made available on that webpage. Now, I am very, very pleased to introduce 3 PTAB speakers for our program today. We will be joined by Vice Chief Judge Mike Kim, Vice Chief Judge Sharon Israel, and Judge Jason Repko. They will each present on their topics, and remember to submit your questions as we go along the way. Now, I'll turn the program over to Vice Chief Judge Sharon Israel to talk to us about our newest study. Over to you, Judge Israel.
Thank you, Janet. It's a pleasure to be here today. Next slide, please. So the USPTO has been studying who are users of the PTAB's AIA trial proceedings system. And for this study in particular, we looked at statistical information, really case docket related information regarding the most active high volume filer patentees, who I'm going to refer to as HVFs or high volume filer patentees, and also domestic university related patentees, which I'll abbreviate as URPs, who are involved in district court litigation for a recent 6-year time period. The time period we're looking at is going to be from January 1st, 2019 through December 31st, 2024. Have one exception, which is we did try to capture some information for directly related PTAB filings for the first calendar quarter of 2025, where there were patents that were directly at issue in district court that were also at issue before the PTAB. Now, the district court cases that we looked at account for more than 10% of all cases filed in that 6-year time period. to look at the other side of the coin too, we also looked at the top PTAB petition filers during the same time period. Now, I'm not going to go into detail about the methodology that we used, but it is included in an overview of it is included in our slides, and details about it are included in the actual study that we'll be releasing. The intent of our study was we examined these high volume filer or HVF patentees as litigants in district court, and we specifically focused on those patentees whose utility or reissue patents were at issue, and how often those litigants, patents of those litigants were also challenged before the PTAB. For the study, we specifically focused on the top 20 HVF patent litigants in district court, although we excluded those patentees who primarily assert design patents or are primarily involved in and or related litigation. On the flip side, we also analyzed domestic university-related patentees, and by that, those are basically those whose patents had originated out of university-related activities and whose patents have been asserted in district court. So we looked at the top 20 for that list as well. For both the HVFs and the URPs, we examined how often their patents are challenged before the PTAB. We did not directly correlate the district court assertions to PTAB challenges, but what we did was look for trends. So what I'll do today is highlight some of our key takeaways and trends. Next slide, please. So what you can see on this slide is the number of PTAB petitions in district court filings. So those will be basically docketed cases. So we had at the PTAB for the high volume filers or the HVFs, 162 petitions filed. At the same time, we had 2,192 district court cases that were docketed. For the domestic university patentees, you see closer numbers, 92 PTAB petitions and 111 district court actions. So in a nutshell, for every 100 district court patent cases filed involving an HVF patent, approximately 7 AIA trial petitions were filed at the PTAB on HVF patents. And for every 100 district court patent cases filed involving a URP patent, approximately 81 AIA trial petitions were filed at the PTAB on URP patents. Next slide, please. Now, looking at the top 20 HVF and URP patent challenges, approximately 35% of the top HVFs whose patents were at issue in district court litigation had patents challenged at the PTAB, while 83% of the top URPs whose patents were at issue in district court litigation had patents challenged at the PTAB during the same time period. Next slide, please. Breaking it down a little further, looking on the left, you can see that about 15% of the top 20 HVFs had patents challenged by district court litigants at the PTAB, whereas they had about 20% that were challenged by somebody other than a district court litigant during that time frame. By contrast, looking at the university-related patents, the vast majority of those challenges against their patents were made by district court litigants. Next slide, please. Okay, so now we'll look at total PTAB challenges versus total assertions in district court. And by assertions, I'm using that term to refer to a patent being at issue, whether it's based on a claim of infringement or generally or non-infringement, which may be, for example, in the case of declaratory judgment actions, where that may or may not have resulted in an infringement counterclaim. So looking at the universe of HVFs, we had 162 assertions where the HVF patents were being challenged by being challenged before the PTAB and 4,292 assertions in district court. So breaking that down, that means for the top HBF district court filers, the percentage of AIA trial challenges to total assertions of HBF-owned patents in district court was less than 4%. By contrast, for the URP patents, the percentage of AIA trial challenges to total assertions of URP-owned patents in district court over that same time frame was about 28%. Next slide. So now let's look at the number of unique patents at issue. And by unique patents, so there may have been more than one challenge of a patent at the PTAB. There may be more than one assertion of patents in district court. And so this is breaking down the actual number of unique patents that were at issue. And you can see that for the high volume filers, we had 112 challenges before the PTAB and 341 unique patents that were at issue in district court. By contrast, for the domestic university related patentees, we had 72 patents challenged before the PTAB and 170 unique patents at issue in district court. Next slide. So looking at that as a ratio, basically 33% of the time that unique HBF patents were at issue in district court litigation, the HBFs had unique patents challenged before the PTAB. Focusing on turning to the URPs, 42% of the time that unique URP patents were at issue in district court litigation, URPs had unique patents challenged before the PTAB. So let's go to the next slide and look at what about the top PTAB petition filers. So the next two slides will show the top 20 PTAB petition filers during the same 6-year time period, excluding design patents. Now, we did not attempt to combine information for petitioners who may be related, as we understand that the relationship between parties can have complexities. So this list reflects the top filers, the top 20 filers based on the first name petitioner. That's how we keep our information in PTAX, and it does not address related petitioners or real parties in interest. You can see that Samsung Electronics, as an example, is the top filer in terms of numbers of petitions filed over that time period. Turn to the next slide, please. And you can see Samsung Electronics America also listed in the top 20. And as an example, we note that that the list includes 2 distinct Samsung entities. Based on a quick check, Samsung Electronics, the top filer, appears to either be an RPI or a co-petitioner in all the cases in which Samsung Electronics America is the first name petitioner. Next slide, please. So, but looking at a whole, the petitions filed by the top 20 petitioners versus the total number of petitions filed, it's nearly a third. So this top 20 group of petition filers accounts for nearly a third of all filers over the 6-year time period. Again, I'll note that this doesn't exclude design patents. It also excludes derivation petitions for when I'm talking about all filers in this time period. So let's turn next and talk a little bit about some takeaways and next steps. So here's just to summarize some of our overall findings. The ratio of the PTAB petitions filed against HBF patents relative to district court assertions is lower than the ratio of PTAB petitions filed against URP patents. I talked about this earlier, basically 7 to 100 for the HBF patents and 83 to 100 for the URP patents. However, the adversaries of the HBFs in district court generally do not file PTAB challenges. The numbers are pretty low. But looking at the ratio of the number of unique patents asserted or at issue in HBF cases and in URP cases to unique patents challenged at the PTAB, those numbers are closer. 33% for HBFs, 42% for URPs. Next slide. But it's also good for us to consider, and we are looking at the time to resolution, the number of petitions, and what kind of impact those might have as well. So it's helpful to also consider how quickly disputes are resolved, especially given the statutory timeframes for AIA trial proceedings. And what we note is that the HVF cases were typically resolved in less than 1 year. That's not true for URP cases. On average, those cases remained pending after 18 months, and less than 40% of them concluded in under a year. As for the PTAB filers, the top 20 petitioners filed nearly 1/3 of all PTAB petitions. Next slide. So what's next? Well, this study will help us inform future rulemaking and practice updates. And we want to hear from you. We do plan to make our case data and our study available for you to review. The case study includes detailed spreadsheet information, and you can look and see what our information was based on. This study is just a start. It is something that we can build on, and we welcome your comments. You can provide comments to our email address at ptabstatistics@uspto.gov. Make that information available to you later. Next slide. So we have in an appendix some of our methodology. I'm not going to spend time going over that right now, but we will make that available to you. And more details are included here, and we invite you to review our study that will be posted on the PTAB Statistics webpage along with the underlying data. And with that, I'm going to pass the virtual baton back to Janet.
Thank you very much, Vice Chief Judge Israel. Now a reminder, if you have questions or comments, please use the email address on the screen, USPTO Hour, all one word, at uspto.gov to submit. Questions come to me. I'll relay them to the speakers at the conclusion of the presentation. Now I'm going to turn things over to Vice Chief Judge Kim, who's going to talk about our multiple petitions study. Over to you, Vice Chief Judge Kim.
Thanks very much, Janet. And also thank you, Vice Chief Judge Sharon Israel, for your work on that study. Very interesting discussion. And yes, we will now pivot to another study. We recently released it, or rather, we recently released an addendum to a study that the PTAB had conducted. And specifically, what I'm talking about is if you go to our statistics webpage, you will find a new item in fiscal year 2026 entitled PTAB Multiple Petitions Study, Simplified Inter-Partes Review Analysis Addendum, which I realize is a mouthful. And it's a follow-up to our main multiple petition studies that we conducted over the years. The first one was issued way back in October of 2017, and the last of which was updated in July of 2023. And those covered the frequency with which patents were challenged multiple times at the PTAB. Now, those main studies focused on the extent to which the same individual petitioners might be using PTAB trial proceedings to challenge an issued patent multiple times, the proverbial taking multiple bites of the apple. If interested, all those studies, again, are on our PTAB statistics webpage. I urge you to locate and look through them. Today's update, however, is on a follow-on. It shifts the focus from individual petitioners to patent holders in the PTAB, with a simplified analysis regarding how often petitions are used to challenge patent claims multiple times in inter-partes review proceedings, regardless of who raised a challenge. So for the time period, it covers all petitions filed from the beginning of AIA through the end of fiscal year 2024 or September 30th, 2024. And this follow-up provides a different perspective and methodology because some patent holders, may not really care whether their claims are attacked by multiple petitioners or just by one petitioner multiple times. In both cases, from their perspective, their patents are potentially being subject to multiple trial proceedings. And similarly, from a resource of the board perspective, when we consider multiple challenges to the same patent, they're largely the same, regardless of whether the challenge came from one or multiple petitioners. So, just to summarize, the main difference in the methodology between the main study and this addendum, as shown in this slide, is that although in the main study, if a patent had two petitions filed against it, only the second petition would have considered a multiple petition. Here, however, when the second petition is filed, both the first and second petitions are considered multiple petitions. So I can understand if you read both the main study and this addendum, you may be scratching your head as to why the results seem different or inconsistent. Rest assured, they're not. It's just because the focus and methodologies are different. So with that, on to the main event. So next slide, please. So with that explanation, what we found was that although the overwhelming majority of issued patents by the USPTO are not challenged at the PTAB, we also found that of those patents that are challenged, many of them are subject to multiple challenges. Specifically, over the life of the PTAB, a little over half of petitions are one of multiple petitions. And breaking that down a little further, about a third of IPR petitions, or 35%, challenge a patent that had already been subject to an IPR. And you can get that 35% by adding the percentages for the second of multiple petitions and the third or greater multiple petitions on the right side in blue. And those are respectively 19% and 16%. Next slide, please. Now, as you all know, board guidance and practice has evolved over time. And to illustrate that, we broke the previous 12-year period into two periods with a break between fiscal years 2017 and 2018. And why do we choose that break? Well, that break was chosen because beginning in fiscal year 2018, the board began issuing guidance on the filing of multiple petitions. In particular, the General Plastics decision, which established factors for whether to deny institution of a trial when multiple petitions are filed against the same patent, was designated precedential. And the punchline is, after that guidance issued, the number of multiple petitions being filed against the same patent decreased. Specifically, before General Plastics, on the left side in green, about 39% of IPR petitions were second of multiple petitions or third or greater of multiple petitions, 20% and 19%. After General Plastics, however, was designated precedential, that dropped to 33%. On the bottom right, if you add the 18 and 14 numbers. Similarly, the percentage of petitions challenge a patent that was not challenged in any other petition rose. So in the upper left in green, it was about 39% before General Plastics. And on the right side, it also in green, it's about 50% after that. So that's, the punchline. I'll note that previous multiple petition studies have been used to support rulemaking. Would not surprise me if this one perhaps is used as well. And more details regarding what is measured and what those numbers mean are available in the appendix of the study addendum, which is posted again on our PTAB statistics webpage. Next slide, please. So with that, I will now move on to our next topic, which is the appeals dashboard. Next slide, please. So we've always published, or for a long time, published monthly statistics about appeals on our webpage, and that's not going away. What we have done, however, is we've added a newly updated PTAB dashboard, which provides, we think, a very easy way to view current historical information regarding appeals. And we'll switch over to the dashboard itself in a second, and you can get there by using the link listed at the top of this page. As a preview, however, the dashboard includes graphs for the appeal inventory by both technology and fiscal year, the number of appeals filed by technology and fiscal year, the average pendency of an appeal by technology and fiscal year, and the outcome by type and fiscal year for fiscal years 2012 through August of fiscal year 2025. As we move forward, the data will be updated as quickly as possible after the end of each month, and the title will be updated to reflect what month and year the data is through. If you have any questions or comments, there is an email listed on that dashboard webpage where you can submit information. Additionally, you'll also see links to each graph that will allow you to jump directly to a specific chart. So with that, we'll switch screens to the dashboard itself. Okay. So taking a look at this first graph here that's titled Appeals Inventory by Technology and Fiscal Year, we have a couple lines that reflects the total number of cases that we have in our inventory at PTAB, and the bars indicate the number of cases in each specific technology area. So I'll show you this cool feature. On the left side, under fiscal year, you can actually select a specific fiscal year or all of them, which is currently listed. So we can pick that one here. And then next to it, you can also pick a specific technology area. So we can pick one there. And then you can press the update button and the information will update to that specific graph. But going back to the all one, you will see that at the end of this past August, we had about 3,500 appeals in inventory. That's that black dot at the end of the line on the right. We also had over 300 biotech cases, a little under 700 chemical, a little over 1,100 electrical and computers, about 1,300 mechanical business methods, and 24 re-exams. And the various colors indicate the technology as shown by the legend below the graph. And the legend also indicates the technology centers associated with that technology. And again, all this information is also reflected in the chart below the graph. So we'll go to the next slide, the next graph. And this graph lists the number of appeals filed by fiscal year and technology. And as you can see, at the left side in 2012, we had quite a peak of appeals filings, and then we had another peak in fiscal year 2017. And then at that point, we embarked on a slow decline to about 4,000 appeals in the past couple of years. Going to the third graph, which is average appeal pendency by technology and fiscal year. This shows the average pendency in months for each fiscal year and technology. And just so everyone's aware, pendency is measured from the time that PTAB receives jurisdiction of the case to the time that PTAB issues a decision on the case. And that's roughly when you would pay the appeal forwarding fee and also file the reply brief. And as a practitioner, we think this is probably the most interesting and useful graph to you. As you know, although inventory gives you some information, what you really want to know, we think, is how long is the board going to take? And so to that end, we actually had a very long time goal to reach and maintain a 1-year average pendency, which we reached in about fiscal year 2012. And this year, under the new administration, we embarked on a new goal to decide all appeals in under 12 months. So a repeat, not an average of 12 months, but all appeals within 12 months, with a few limited exceptions. And I'm pleased to report that we succeeded. We reached that goal on September 30th. It was a great monumental effort by everyone here at the board. And we're going to work to at least maintain that going forward. Hopefully this provides you even more certainty when you consider options after final rejection. Finally, the last graph I'm going to show you is the outcome for each appeal, affirmed, affirmed in part, reversed, dismissed, or remands by fiscal year, and they're reflected by the colors indicated in the legend below the graph. And here, I actually think that the graph is not so useful. It's more the table below it that's going to be useful, because those provide you outcome percentages. And over the years, the results have been relatively steady. About 55 to 60% of appeals are affirmed, so all claims still being subject to at least one rejection. And between 30 to 35% of appeals are reversed, where no rejection on any claim is maintained. So those are all the graphs. Finally, just going to the bottom of the web page, we also have 2 bars. There are links to additional PTAB statistics, as well as our PTAB open data portal. And in the future, we also plan to expand upon the dashboard to include additional functionalities, as well as a separate dashboard for AIA trial statistics. So I'd like to thank everyone in the audience for your time. I'd be remiss if I didn't thank my colleagues here at the board, lead Judge Dave Kohut, Judges Scott Howard, Charles Greenhut, Jason Morgan, patent attorney Brandy Zukanovich, and countless others in our information technology and data analysis teams who really do the real work behind the scenes, both in preparing the content and also assisting me to present to you those previous two segments. So with that, thanks again, and back to you, Janet.
Thank you very much, Vice Chief Judge Kim. So this is an opportunity and a reminder. Please submit any questions or comments you have about the different segments we're talking about to the email address on your slide, USPTO all one word, at uspto.gov. We'll now move into the last segment of our program before our Q&A with Judge Jason Repko, who is going to talk to us about the Orange Book patent and biologic patent study, along with updates to our trial statistics. So over to you, Judge Repko.
Thank you, Janet. So I'll be presenting a report on AIA trials involving petitions challenging Orange Book listed patents and biologic patents. It's an updated version of a study that we published back in March of 2024. We first published the Orange Book study in 2018, and we added biologic patents to the study the following year. The data behind this study is published on our website and on the statistics page. So generally what we mean by Orange Book listed patents, it's a shorthand for patents covering FDA-approved drug products that are listed in the FDA's Orange Book. Biologic patents are a little different than Orange Book patents because biologics are large, complex molecules such as vaccines that are made from natural sources. The FDA produces a Purple Book, which lists the FDA-licensed biological products, but the patents in this study are not restricted to those. We manually identified biologic patents as any patent potentially covering a Purple Book listed product and a non-Orange Book listed patent directed to treating a disease or condition. This slide shows an overview of the findings from our study. 3% of all AIA petitions challenge Orange Book listed patents, and about 2% of those challenge biologic patents. The challenges have fallen from a peak of about 7.5% of all petitions filed in FY16 for Orange Book listed patents to less than 1.4% of all petitions filed this fiscal year. Challenges to biologic patents have been more steady, but fewer since 2017. Next slide. So PGR petitions are used more often when challenging biologic patents compared to Orange Book listed patents. The institution rate for biologic patents and Orange Book listed patents are about the same, very similar, 61 and 62%. Orange Book listed patents have had a greater percentage of claims upheld in a final written decision, though, when compared to challenges to biologic patents. Next slide. Slide shows a breakdown of all petitions filed challenging patents in different technology categories. And this is all time from September 12, 2012 to the end of July. That's when we stopped our study. Most of them fall in the electrical computer area. And so we categorized the petitions by the patent that they challenged and which TC issued that patent. So the electrical TCs at the USPTO would fall in the blue category. And for example, the other biopharma would be TC 1600. And we categorized the remaining petitions according to whether they challenge biologic or Orange Book listed patents. And so those are typically a subset of those found in TC 1600. So that's why you see three separate categories there, one for other biopharma, sort of a cyan, and then orange and purple. And here shows really only about 3% of all of these AIA petitions challenge Orange Book patents, and only about 2% of those all-time challenged biologic patents. Next slide. This slide shows how that has evolved over time, showing the filings of petitions challenging Orange Book listed patents categorized by fiscal year in which they are filed. And you can see FY15, for example, we had 133 petitions, and FY16 was our height in terms of the percentage of petitions filed as a total of all petitions filed, and that was at 7.5. And so challenges to Orange Book listed patents have fallen from that peak in FY16 to less than about 1.4% of all petitions filed this fiscal year. Next slide. This is a graph showing all petitions challenging biologic patents by fiscal year, and you can see it's a little bit more steady, but fewer since 2017, 75 total, and about 30 total through the end of July. Next slide. Look at the petitions filed by trial type. All time is on the far left. It's all technology categories. And you'll see about 94% are IPRs. On the far right, you'll see biologics, where challenges to biologic patents, about 87% are IPRs, and about 13% are PGRs. So PGR petitions are used more often when challenging biologic patents when compared to the other two pie charts here showing Orange Book patents and other technologies. Next slide. Here we look at a trend over time of the different trial types for Orange Book, and you see for PGRs, it's relatively flat. Very few PGRs are used to challenge the Orange Book listed patents. Most often IPRs are used. Next slide. This is in contrast to the biologics, especially with FY25 year to date. You'll see that from 2017, 2014, it's been less than 10. FY25 year to date, we see 14. So petitioners generally use IPRs and PGR petitions, but IPRs most frequently. And then FY25 year to date with 14 is much larger than we've seen in the previous fiscal years. And again, this is through July 31st. Next slide. We also looked at institution rates for petitions challenging Orange Book listed patents. And you'll see that very few, again, you can't really draw any trend lines here because of this, so few DIs have issued here, decisions on institution. And so obviously you look back at FY16 and 17, that's where most of the activity was. Next slide. And we did the same thing for biologics, and you'll see the gray bars is where we instituted, the denials are red, and then the line at the top, the line graph showing the institution rate for that particular fiscal year. Next slide. Overall, as we said at the outset, the Orange Book and biologic patents, they have similar institution rates at 61 and 62%. That's pretty close to the overall. You'll see for all institution rates that are kind of clustered in the 60s there, all pretty stable. Next slide. We also looked at the outcomes for the petitions challenging Orange Book listed patents. So for every petition, we looked at the termination, how that case terminated, and we put it in this pie chart here. So for final written decisions, patentability or unpatentability is reported with respect to the claims at issue in the final written decision. Some may have dropped out over the course of the proceeding. We've also excluded joint cases here, so then the numbers might not quite match up with the previous slide where we included the joinders. The outcomes on decision on institution responsive to requests for rehearing are included in this one. This is sort of like looking at the termination, how it terminated overall, and institution rates, we sort of excluded those outcomes on decisions on institution requests for responsive requests for hearing. Next slide. We also did the same for biologics. Again, as you'll see that the Orange Book listed patents had a higher percentage of claims held up on final written decision. Here it's 18% or 18, which is about 6% compared to with the Orange Book listed about 14%. Next slide. We also looked at an aggregation of results for a given patent. So here, rather than looking at every petition, we look at the outcomes of patents. And so 315 Orange Book listed patents were challenged. And these are the different outcomes for each one of those patents. The institution denied 32%. And for example, would be if the patent was challenged, multiple times, the net aggregate of that was an institution denied for that. So for example, if it was a mixed outcome, if there was more than one outcome. So the mixed outcome is shown for patents receiving more than one type of outcome. For example, denied and settled would go into the mixed outcome. If a patent is in the final written decision category that ever received a final written decision, regardless of the other outcomes. There are multiple final written decisions. The individual claims are examined to see what is the net outcome. Is it all challenge claims unpatentable, or there is some sort of mixed results, and that's that FWD mixed. So that would mean some claims were found patentable and some were found unpatentable when you aggregate potentially multiple final written decisions. Next slide. And we also looked at the same thing for biologics. Next slide. This is a bar graph. It shows the claim outcomes for Orange Book listed patents. So we looked at the outcomes like on the previous slide, except we kind of broke it down by claim. And we showed on the far left the number of claims that are actually in each patent challenged. And we broke it down and figured out which of those claims are challenged and kind of divided them up in different colors. So as you progress from left to right on the bar graph, you go through different stages of the trial. And at the very end, we showed that about 17% of challenged claims and about 33% of instituted claims were found unpatentable by our standard of preponderance of the evidence. Next slide. The same thing for biologic patents. And what we found there was about 27% of challenged claims and about 59% of instituted claims were found unpatentable by preponderance of the evidence. That concludes the Orange Book and Biologic study. If you go to the next slide, you'll see that I want to pause and remind everybody that if you have questions or comments during the webinar, please email usptohour@uspto.gov. Next slide. So we also updated our PTAB trial statistics webpage with additional roundups, outcome roundups we call it. So let's go to the next slide. We'll start with that. And so we published this on a quarterly basis, and it shows the outcomes by petition for all trial types and all different technologies. And here, with these outcome roundups, we've added a category for Director Discretionary Consideration Decision, which we call DSCO, and a separate category for denials. And so here you'll see this red piece of the pie chart showing those decisions. And so that's the new addition here to this particular graph. As you see in the previous study, we didn't show that category. And this is through, published this back in June. Next slide. Here's the same slide, and we've also, or the same kind of view, that we've also added the Director Discretionary Consideration Decision for outcomes by patent. Next slide. Outcomes by claims challenged. It's similar to the bar graph, but here again, we've added that additional category. Next slide. And again, the Director Discretionary Consideration category was also added to our claims outcomes. Again, we publish these on a quarterly basis. If you go to the next slide, we have the trial statistics that we publish on a monthly basis. Again, these are not outcome specific. If you go to the next slide, we kind of show generally petitions filed by trial type for the fiscal year. That's, as you look at the top, you'll see FY15, the start of the fiscal year, through the July date. And we kind of show a breakdown, petitions by trial type. Next slide. We also give you the same view of the petitions filed by technology, just not broken out by Orange Book or biological. A lot of those fall within the biopharma, that purple slice there. Next slide. On this slide, we show our petitions filed by month. This one shows previous 12 months, so you can see the different trends and filings of IPRs and PGRs. Next slide. We now have we've added recently to our monthly statistics disposition rates by decision type. So here on the left, we're showing director discretionary consideration decisions. We had 286 as of July 31st, 2025. 171 were denied, and 115 were referred to the panel. On the right, you have the board's decision on institution, where the board denied 301 out of the 876 decisions or petitions, and granted 575. Next slide. We've also updated our institution rates by petition to break out the director discretionary denial decisions, DSCO denied in red. See that red hatched area? That's where you see that 171. And we kind of incorporated that into our institution rate of 55%, treating those director discretionary consideration decisions as a denial. Next slide. Here we have our standard institution rates by patent, which we've kept the same. Next slide. And also the institution rates by technology that we publish on a monthly basis is sort of unchanged. Here, the institution rates for each technology is calculated in the same way, dividing the petitions instituted by decisions on institution. The outcomes and decisions on institution responsive to the request or rehearing are excluded here. Next slide. This is the settlement rate. We publish this on a monthly basis. This is through the start of the fiscal year. It's the total settlements by complete proceeding each fiscal year, excluding joint cases. And I'll turn it back over to Janet.
Thank you very much, Judge Repko. Okay, we've wound down. We have about 10 minutes left to take your questions. So this is your last chance to submit them. Please use the email on this slide, USPTO Hour, all one word, at uspto.gov. If we can take the slides down now, we'll all come together and talk through some of the questions that our audience has submitted. So my first question will go to Judge Israel, and it has to do with the high volume filer study. First of all, you mentioned that we will be able to find the study and all of the underlying data. Can you tell us where exactly we can locate that information? Where is it posted on our USPTO website?
Certainly. It's not posted quite yet, but it will be posted soon. It's going to be on our PTAB statistics webpage, which is at uspto.gov/patent/PTAB/statistics. And just to give you a little bit of a highlight of what's included there, it includes basic docket information for all the proceedings that we were looking at, both in district court and AIA trial proceedings for individual top HVF filers and URP filers on a proceeding by proceeding basis. And you'll see some notes we have that are included as well. And I think you should be able to manipulate the data and take a look at it and see what some of the basic numbers and statistics that we were able to develop from those, where that came from.
Thank you. And then a follow-on question about the takeaways from this study. You observed that high volume filer district court cases are resolved on average in less than 1 year. Did you take into account how often there were settlements in those cases and how settlements may have impacted the outcome?
So no, we did not take into account settlement specifically. That was a little bit beyond the scope of the study, but we did, look at timed resolution of cases. And we did, I should say that we had to draw a line in the sand in terms of the time frame that we were looking at. So the data that we had is through a date in May of 2025 in terms of whether cases were terminated or resolved by that date, whether it was by settlement or otherwise. I will also note that we, in order to try to not double count cases, we did try to account for cases that had been transferred. And so if a case had been transferred, we only counted it once. Whereas if a case had been dismissed and a party might have refiled, whether it was a same or slightly different complaint, that did count twice. But if it was a transfer, we only counted that docket entry once.
And if members of the public want to make a comment on this study or on any further developments that flow from the study, you mentioned possible rulemaking, how can a member of the public submit those comments?
Yes, well, we welcome comments, and I think this is just the start. Please submit comments to PTAB statistics at uspto.gov, and Brandy has put that email address in the chat.
Thank you. We talked about a lot of different topics, so I want to turn now to the PTAB multiple petition study. So the next couple of questions are going to Vice Chief Judge Kim. So first of all, just to make sure everyone understands, can you explain the difference in the context of this study when you use the terminology one of multiple petitions and additional petition? What's the difference?
Thanks very much. And that's a great question. And that's a very key point. So thank you for that. Yeah, so the simplest way to explain it is if you have two petitions, the first one is an initial petition and the second one is an additional petition. So you have one initial petition and one additional petition. However, when we did the addendum, we introduced the term one of multiple petitions. So in that case, both the first and the second petition would each be one of multiple. So that would count as two petitions.
And then how were joinder petitions accounted for in this study?
Thank you very much. That's a great question. The short answer is it was not. This was a simplified analysis, and so we wanted to keep it easy. So yes, we didn't really take any special circumstances like joinder or other things into consideration. So substantively then, if you had an initial petition and then you had a second petition that was a joint petition, those were counted as separate petitions. So again, those would be two of one of multiple petitions.
Thank you. I'm going to shift, and you also talked to us about the appeals dashboard. So I want to spend a couple moments with it. We have some questions. When can we expect to see a companion AIA trials dashboard?
Yeah, thanks very much. I'm very excited for that, and we hope to have it pretty soon. What we were actually waiting on was to complete our monthly trial statistics, and particularly to get the processes going so that we could account for the director discretionary decisions. So now that we have all that in place, we think it'll be relatively straightforward to take our monthly stats on those slides and convert them to a trial dashboard format. So we're optimistic that we can have it out pretty soon.
And then as far as the appeals dashboard, how frequently will the data be updated? Is this an annual update, a monthly update?
Absolutely. We are totally targeting a monthly update, and we think it kind of makes sense to have the same cadence as our monthly appeal statistics. So right now, I believe it is updated through August 31st. And now that we're a little bit into October, we're hoping that we can get it to September 30th relatively soon.
Great. And if a member of the public has a question about the dashboard, since this is a new feature, they may not fully understand how the data is presented, is there a resource that they can consult? Is there a telephone number, email address? What should they do?
Absolutely. So on the webpage itself, at the top, there is an email address for PTAB statistics questions listed there. So you don't have to remember it. It's there, easily accessible. So yes, we absolutely welcome any feedback on it. We really want this to be useful to you in helping you and your clients make decisions on what to do during prosecution.
Well, thank you, Vice Chief Judge Kim. Let's talk about the last two topics, the Orange Book and biologic study and our trial statistics. We have a couple of questions on those areas, and I'm going to turn now to Judge Repko. So on the Orange Book study, was there a particular reason for doing a separate study focused on Orange Book patents and biologic patents versus all the other types of technologies that the board handles in its docket?
So as I mentioned at the outset, this is a follow-up to several studies that we've done over the years. We first published the Orange Book study in 2018. And we made this data available to the public. You can go on the website and look at the open source data that we have. But yeah, this is just an update to a study that we've been doing for several years now.
So, given you have several years of experience, are you seeing any differences over the years between the filings that are challenging Orange Book and biologic type patents versus the challenges to other technological areas?
Yeah, I think if you look at the institution rates, it's pretty much in line with the overall institution rate. You look at the 61%, 62%, pretty close to the overall institution rate of 64%. And again, in recent years, there's been so few, so you really can't judge you can't really compare the recent institution rates as well to the overall technology because just the sample size is so small.
Thank you. And then on the statistics, the discretionary consideration decisions, of course, generated a question. So I'm going to ask you, disco cases, that's the term I always use to refer to them, seem to deny more often than they refer to the panel. But on the other hand, the board's institution rates, both by petition and by patent, seem higher than 50%. So what are the reasons for these perhaps contradictory or seemingly contradictory results?
We didn't look at the reasons in the statistics. We just kind of reported the outcome. Yeah, it was, as you mentioned, about 60% of the director discretionary consideration decisions deny, and you take that 40%, the remaining 40%, that goes to the board. And then the statistics that we presented, it includes all the decisions throughout the entire fiscal year from October 1st to July 31st. So it's important to keep in mind that those decisions also include, the pre-bifurcated process board decisions. So in that case, we had, 34% denials and 66% granted, which is pretty close to the overall institution rate that we've seen, by petition in the previous years, which is in FY21, we had 58, FY22, 66, FY23, 67, 68. So that 66% right there, the granting of the decisions on institution is pretty much in line with that.
Thank you. I guess that distinction of what the scope of the data includes is really important to keep in mind when looking at those updated trial stats. So when do you project end of the year statistics will become available?
Yeah, we're still finalizing the data. I don't have a firm date yet, but it should be soon.
But we can anticipate it very soon, correct?
Yes.
Terrific. Well, looking at the clock, I see that our time is over today. Remember that the slides we presented in this episode and a recording of this episode will both be made available on the USPTO Hour webpage very soon. I want to extend thanks to Judges Israel, Kim, and Repko for sharing your time, your expertise with us today, and to all of our attendees, thank you very much for joining. This concludes our program for today. Please tune in to the next USPTO Hour next Wednesday at 12 o'clock. We'll see you then.